to another edition of the program Legal Matters coming to you on TDN Africa Media. I am your host, Amadu Esba, and with me in the studio, I have Mr. Emmanuel King, who is a practicing lawyer and also our usual contributor. Today, we'll be discussing about the difference between civil and criminal law using the LJ judgment as a case study for the criminal law. Mr. Emmanuel King, you're welcome to this edition of Legal Matters.
Yeah, good morning, Mr. Ba, and thanks for having me. Good morning, viewers.
And we are now again on another edition, and today we want to look at the differences between that of a civil law and that has got to do with the criminal law, using the LJ judgment as a case study in the area of criminal matters. So to start with, for the understanding of the public and for us, the layman, as you've always described us, what is a civil law to start with?
Okay, I think today we have a very interesting topic to discuss, because civil and criminal law are very interesting regimes of the law, even though they are separate and diverse branches of the law, because civil law actually deals with it deals with the day-to-day activities between individuals, between organizations, or between an individual or an organization. Okay. So disputes that arise in the dealings, in the transactions and contracts between private individuals and organizations, or between these private individuals and organizations, or between private individuals themselves, or between organizations. These are considered under the civil law umbrella in the aspect of the law.
Okay. So
it's quite separate and distinct from what obtains in the criminal law aspect, because predominantly the criminal law deals with crimes, okay, which the citizens of a country commit against the state. Okay? We hear also about crimes against humanity. These are all regimes of the criminal law. Okay. So there are certain features of the criminal law which we will discuss, that you will see separate and distinct features from what obtained in the civil law. But for the purpose of paraphrasing, civil law has to do with disputes that arise between transactions that take place between private individuals or organizations, corporate outfits, institutions, or private individuals between themselves, or private individuals between these organizations. So the disputes that arise from their transactions, okay, from their contracts, okay, from their engagement, is what the law seeks to make very easy for them.
Okay, so now you mentioned you would like to talk about the attributes of that of criminal law and that of the civil law. Now let's start with the attributes. What are the attributes of a civil law?
Well, we cannot more call it attributes. We can more say these are elements or features.
The features.
Yes, or features that are likened to what is considered to be civil. What is considered under civil law. Okay. Yes, or what is considered under criminal law. Okay, as I have said. The definition itself of the two sets the tone for the distinguishing feature between civil and criminal law, even by the definition. Okay. You will now see that for civil law, as I have said, the issues that arise are disputes between individuals, private individuals. Okay. Okay, disputes between private individuals in their business transactions, in contracts that they enter into and the likes. Disputes that arise between organizations. So for instance, now the Bank of Sierra Leone gives loan out to TDN as a corporate outfit, and TDN defaults in that particular loan. So before they give out the loan, there is definitely a piece of contract that would have been exchanged between the two entities. So the courts now will now look at this particular contract, the clauses that you put under this contract, the terms that you agreed to under this contract, to determine, as a matter of fact, who went wrong between the two parties. Okay, so let's say, for instance, we have the landlord and the tenants. You know, the tenancy agreements that binds them. When we get to a situation where the tenant can no longer pay his rent and the landlord takes him to court for eviction proceedings. These are all examples of matters under civil law. Okay. But this is not what obtains when it comes to criminal law. Okay. Criminal law has to do with crimes against the state. Crimes against the state. Crimes that have been put down in law, that once you violate these things, you have committed a crime against the state. And so we see a situation where these offenses are prosecuted by the state. When I say the state, I mean the government. So we can now interchange government for state in this discussion. Okay, so where I say government, I mean the state. Where I say state, I mean government. So under criminal law, it is the government or the state that brings the action against the individual. Okay. Whereas in civil law, it is the plaintiff, the private individual, or the organization that will bring the litigation against the other person.
Well, we do know that in our court setting we do have the magistrate courts, and then we have the high courts, we have the Supreme Court, and then we have the appeal courts. In all of these courts, which of the courts actually look at matters that are got to do with civil cases?
Okay, in our jurisdiction, as a matter of fact, magistrate court matters deal with both criminal and civil matters. Okay, they just have a certain a threshold with regards to matters that they should handle. They have, so we call it jurisdiction at law. Okay, the magistrate court cannot exceed its jurisdiction in certain cases. So there was an amendment to the act with regards to the matters that will come before the magistrate court. So any matter that now exceeds 50 million old loans, 50 million old loans, any matter that exceeds 50 million old loans is above the jurisdiction of the magistrate court. So if it's a civil matter and it involves a transaction that exceeds 50 million old loans, it cannot be, this is a matter that the magistrate court does not have the jurisdiction to hear. So it would have to transfer that matter up to the High Court. Okay, so we have different divisions of the High Court. Yes, we have different divisions of the High Court that handle different matters.
And what are these divisions?
Okay, so we have the General Civil Division, we have the Fast Track Commercial Court, we have Land and Property Division, you know. So we have all these different divisions of the High Court that deal with varying civil matters and criminal matters. We even have the ACC Court. We now have the Sexual Offences Model Court. So these are all different divisions of the High Court. So the High Court is one, but it has different divisions to look at different offences that come before the court. So so now for us to go back to the difference between the civil and criminal law, I told you that we have to look to certain features to be able to see the distinction between civil and criminal law clearly. Okay, we've talked about the definition. Okay, we now have to look at the burden of proof. Okay, so the burden of proof sets a clear distinction between what will be considered as an offense under civil law and an offense under criminal law. So for the purposes of criminal law, the burden of proof is beyond all reasonable doubt. If we are to put it in percentage terms, beyond all reasonable doubt will be about 99.9%. So you have to prove your case. The prosecution is the one that has the duty in a criminal trial to prove that the accused person is actually guilty. So in a criminal matter, when an action is begun against a particular accused person, it is the prosecution that should prove. This was set out in the case of Woolminton versus BPP of 1935. So if you now go to court, you will always hear the judge or the prosecutor or even the defense team will now make reference to Woolminton versus DPP of 1935.
Okay.
It is in this case that Lord Viscount Sankey set out that it is the duty of the prosecution to prove the accused guilty beyond all reasonable doubt. It must do so beyond all reasonable doubt, because this is a criminal matter. The last time we spoke about the spirit and intendment of the law. Okay? So because this is a criminal matter and the livelihood, the convenience, and the freedom of someone is at stake.
Okay.
It's at stake. So we have to do everything to make sure that if a criminal conviction comes the way of this particular accused person, it has to be that he is the one who actually committed this crime. That is why the threshold is so high. That is why the threshold is so high. The burden of proof is on the prosecution, and it is so high. You have to show to the court all substantial evidence. You have to prove all these pieces of evidence before the court that, as a matter of fact, this accused person is guilty of this offense.
Okay.
So like I said, in percentage terms, that would have to be 99.9%. So it has to be clear, beyond the shadow of a doubt, that this person is really the person who committed this offense. Whereas in a civil litigation, whereas in civil law, it's called the preponderance of evidence, which is the balance of probabilities.
Okay.
Okay, so a balance of probabilities in percentage terms is just over 50%. So if the plaintiff in a civil matter, if the plaintiff can show or prove in court over 50% that the defendant is liable just over 50%, if he can show that the defendant is liable just over 50%, then the court will be satisfied that, as a matter of fact, this defendant is liable. Okay, so this is a marked distinction between the criminal and civil law.
Okay.
The burden of proof.
The burden of proof, and you say for the civil law, it has to do with
the preponderance of evidence, which we call the balance of probabilities.
Okay.
Okay. So the party that brings the other party to court, which is the plaintiff, he brings the defendants to court. You know, he has to be able to prove to the court on a balance of probabilities. So you see the scale. If you look at you will see a scale that holds the balance. Okay, you will see a scale that holds the balance. If that balance tips in the favor of the plaintiff, just a little bit as against the defendant in a civil case, okay, then the court is compelled to bring liability against the defendant, because it's the plaintiff in a civil matter just have to prove over 50% that, as a matter of fact, the defendant is liable for the offense before the court.
Yes. And another thing I believe our viewers may like to understand, we're coming in depth into criminal matters. We want to look at civil matters, basically because people want to understand what are the types of crime that indicate that this is a civil matter or a criminal matter.
Okay, as I have said when I was setting the premise, especially when I was talking about the definition, you see civil matters arise in disputes between private individuals.
Of course.
Okay, whereas, but that is also a generalized statement, because criminal matters can also arise in disputes between private individuals.
I just wanted to.
Okay, so we have certain examples which I will state for people to get a broader understanding of what I'm talking about. For example, in criminal matters, we see a crime such as burglary.
Okay.
You will see assault occasioning grievous bodily harm. You will see battery. You will hear things like murder. So these are all crimes. Okay? These are crimes, and you will find them under criminal law and criminal prosecution.
Okay.
Okay? Whereas for civil law, we see the likes of eviction. Okay? We see negligence.
Okay.
We see malpractice. Okay? So you see these types of you cannot call them offenses under civil law. Okay? So when issues of negligence happen, you find them under civil law. So for instance, what do we mean by negligence?
Yeah.
Okay, what do we mean by negligence? It comes in a number of forms. Okay, to be negligible in one's act. Okay, but we can find negligence in criminal acts and in civil acts also. But for the purposes of civil law, say for instance now, I am a chartered accountant, and I was asked of my opinion on, well, for instance now, I was contracted by someone to give him an opinion on costs of a particular commodity in the market. This person is going to now rely on my expert opinion. The person is going to rely on my expert opinion as a chartered accountant.
To reach a particular decision.
Yes, to make a particular decision. And I arrived at this particular opinion in a very negligible way. Okay? So, and this particular individual who contracted me relied on the opinion that I gave him to his detriment. He suffered some loss as a result. Okay? So he suffered some loss. He relied on my representation, so it's called a representation. My opinion now is now a representation. So he relied on my representation.
Okay.
So his detriment, and he suffered some loss. So in civil law, you have to show to the court that you relied on the person that you are bringing the action against. If it's in the capacity of his representation or his opinion, you relied on it to your detriment, and you suffered some loss. So you have to show that, you have to show the reliance, you have to show the detrimental aspect, and you have to show the injury or the loss that you suffered before you can ask the court for a relief. Okay? So once that happens, the court is now compelled to say, yes, as a matter of fact, this chartered accountant was negligible in his opinion, and you have suffered loss as a result. So they will now compensate you. So this is another distinct feature between a criminal and civil law. The aspects of what happens at the end of the day, at the end of the trial.
Well, we are going to come at that, but since
yes.
you started talking about it, let's just continue from that.
Yes.
Yeah.
So what happens at the end of the trial? So if the plaintiff in a civil matter who has brought the litigation against the defendant, the other party, if he succeeds in a civil matter, okay, he will be compensated through damages or relief by the court. So the court will now look at the situation, the evidence that came before it, and say, okay, this is the position that this person would have been had it not been for what you did. Okay. You're the defendant. So this is the position that the plaintiff would have been had it not been for what you did as a defendant. So the court tries to put back the plaintiff in that position that he would have been, or compensates the plaintiff for an act that you did for which he suffered loss. Okay. Or in some other instance, returns certain monies. So for instance now, the man puts his money in his bank account and the money disappears, and he brings an action against the bank. Okay, so the court will now look into his case, and if he can prove not beyond a reasonable, beyond balance of probabilities. Okay, on a balance of probabilities, if he can prove over 50% that as a matter of fact, it is because of the negligible act of the bank that he lost his money while it was in the bank account, then of course the court can now ask for him to get his money back. in some special circumstances, the court can even ask that he's given more for the time that he has wasted and the cost in the cause. So it is called a cost in the cause. That, for instance, now the man has taken a lawyer to come to court.
That's one case.
Yes, for this particular issue, for him to recover his money that he has lost in his transaction with the bank. So because he has now taken a lawyer, he has now been involved in some extra expenses. He has spent some more money. In addition to the money that is lost in the bank, he has now spent some more money to now secure the services of a lawyer. Okay, so the court looks to that. He cannot suffer all this loss. You, the person who occasioned the loss, will have to pay for that. So in the pleadings, the lawyer will now skillfully just put in costs in the cause, which means that at the end of the trial, all the costs that the plaintiff incurred to bring the matter to the court and for the subsistence of the matter in the court, you, the defendant who has failed in your case in the court, will now pay for that.
And now back to the area of I don't know how to put this, but you've already stated that we do have some basic liabilities that can fall under civil law. Do we have them? Do we really have them? And which are they that you can consider to be civil matters, like the street liabilities we talked about the last time?
It's quite difficult for you to find strict liabilities under civil law. You generally find strict liabilities under a criminal law. Okay?
And why is that so?
Yes, because it is a state of affair offense. Most strict liability offenses are state of affairs offenses, which means that you are found on the height doing this particular act which is prohibited. So you find out in the last session, I gave examples of strict liability offenses.
Yeah.
Okay? Like driving under the influence of alcohol.
And the reason why I asked, a lot of people, to them, they consider this to be because of and I don't know the law determination, what the law actually means about civil, but for the common saying, oh no, this is a civil crime. I don't think I did anything big. So that's the reason why I made mention of it.
So why you hear people most times talk about that?
Yeah.
It's a civil offense. Even when you go to the police station to report certain matters, they will now tell you that it's a civil offense. So you people can go out and try to find a way to solve it. If the person is continuously aggrieved, they can now take the matter to a private practitioner who will institute an action for him in court. So when they say you institute an action, it means you start a litigation in court. You start a legal matter in court. So most civil matters are litigations that are begun in court. Whereas for criminal matters, most of them are begun in the police station. That is where the investigation actually starts.
Okay.
Yes, for criminal matters, but most civil matters. For instance, now issues of negligence, malpractice, and the likes. You know, so some people enter into ususu arrangements. You know, ususu arrangements, and they've been in this ususu arrangement for some time. You know, for some time they've been in the ususu arrangement. And then one day the Ususu master says there is no money for me to pay you. You know, so they will now bring the matter to court because it's a civil matter, you know, and then the practitioner will now argue the case in court, you know, the preponderance of evidence will come before the court, and as long as the man can prove over 50% that he gave you his money and he was expecting that, you know, the money should now come back to him and the money does not, then the court will now give him decision. But it's not so straightforward. That is why people go to court, because these offenses, they have elements that you have to look at. You have elements, as both criminal and civil offenses. The law prescribes certain elements that you have to prove in the court.
What are the distinct elements of civil?
In passing, just now, as I was speaking about negligence, I spoke to some of the elements, you know, because I was now talking about the fact that you have to prove that you suffered loss as a result of your reliance on the representation that the accountant made. Okay, so you have to look at all these elements and you have to prove them one by one, one after the other, in the court of law. That first of all, I contracted this chartered accountant. And secondly, he made a negligent misstatement of the opinion that he gave to me.
Okay.
And thirdly, I relied on this particular representation to my detriment.
Okay.
And I have suffered some loss. Because I now invested in this business, which he advised me to invest in. And I have, as a matter of fact, not seen any profit forthcoming. Or I have lost all my money. And I relied entirely on it. So you have to prove all of these things, and the court will now look and say, okay, well, you see, the man has actually proved his case, so you have to return his money, his entire investment that he's put into this business, or the court will determine the circumstances of the case. You know, because most times when decisions come from the court, we have the public that will have an opinion on these decisions, not taking into cognizance that the court have to look at the entire circumstances of the case and the circumstances of the defendant or the accused person, as the case may be. In criminal matters, at the end of the trial, there is what is known as plea in mitigation.
Okay.
Yes, so you, the legal representative of the accused person, you are given an opportunity. So, for instance, now in the instant case of LEG, which the court has now come to a determination of the matter. In that case, the defense counsel was given an opportunity to now plead mitigating circumstances, why the court should consider not giving him the maximum sentence for the offense for which he has been convicted.
Okay.
So, pardon me. Okay. So this is a situation where you now hear the representative, the legal representative will say, my lord, this is a first-time offender, you know, he has a family, he is the sole benefactor of his family, the life of his wives and his children will undergo very strenuous situation because he is the breadwinner and is going to be incarcerated. You know, even though we are here for justice, we ask that you temper justice with mercy. So the representative will pray to the judge to consider that this is where you hear this phrase most times, temper justice with mercy.
Yeah.
So now we've come to a point where the man has been convicted. There is absolutely no argument there. But you now have to canvass the judge by the unique circumstances of the man. He's a first-time offender. He has never committed a crime in this country before. You know, he is an upright and upstanding Sierra Leonean who is a tax-paying Sierra Leonean. He has been contributing to the consolidated revenue fund of this country by paying his taxes regularly. He is a businessman of no mean repute. So you can make all his arguments in favor of, even though he has been convicted. And the judge will now consider that, well, given this unique case of this particular accused person who is now a convict, even though the maximum sentence for this crime is 15 years, I will now sentence you to 2 years imprisonment. You know, I will sentence you to 2 years imprisonment, given your special circumstances. Okay. Yes, given your special circumstances. So this is what the court looks at most times, the entirety of the circumstance of the case. You know, so once that is considered, then certain decisions will come forth from the court. And this is what most times society, the general public would not understand, and everybody would have their opinion. Why was this man for the same offense sentenced to 15 years, whereas this man for the same offense, he was sentenced to just 3 years? You know, because their circumstances are not the same. Okay. So, for instance, now this man will be aged 45 years, and this other man will be aged 18. You know, at 18 years, he's a first-time offender. You know, he's a very, very young man, even though he has come to adulthood at that age, but he's still a very, very young man. You know, he does not fully appreciate what he was doing. So the court can look at all of that and say, okay, we'll give you a relaxed sentence. So this happens mostly in criminal trials. Okay, so with regards the punishment, so we'll now go to another feature which distinguish between civil and criminal law, which has to do with the punishment at the end of the day. I have spoken to it in passing, but we have to speak to it in detail.
Yeah.
You know, at the end of the civil trial, at the end of a civil trial, civil litigation, we see compensation from the court to the person who actually won the matter. So if it is the plaintiff, in the instant case, he won the matter, the court will compensate him for his loss, the loss which I have stated in my example. So the court will compensate him. You know, there are certain cases where the plaintiff will plead to the court for specific performance. So for instance, now I want to attend a marriage ceremony, okay? And I contracted a tailor man. A tailor man, you know, we have these tailors, okay? I contracted a tailor to do me a suit, okay? I told him I want this suit on the 5th of April.
Okay.
Yes, I want the suit on the 5th of April. And so I now go to this tailor man on the 5th of April and ask him, I have paid for my suit, you have had enough time, where is my suit that I paid you for? And the tailor man now says, oh, I forgot to work on your suit. So I now bring an action against him in court. The marriage ceremony is for the 30th of April.
Okay.
Because I want to be comfortable, that's why I gave him the date for the 5th of April.
Okay.
Yes. So I now plead to the court for specific performance. I want him to now make my suit.
Wow.
Yes, I want him to. So the court will now speedily order him to go and do my suit before the set date for the marriage ceremony. That is if I want, that is if that is what I plead to the court, what I pray for the court to give to me in a civil matter. That is what I pray to the court to give to me. But if that is not what I pray to the court for, I want him to give me back my money, then the court will now ask him to give me back my money, and he will now pay costs for the lawyer that I contracted for the matter and some other reliefs.
Just when you mentioned about you paying the illustration that you just did regarding paying someone, you know, we do have, it is very much common in our society. Does that fall under criminal law, what we call breach of contract?
No, a breach of contract cannot fall under criminal law.
And from
breach
what
of contracts are mostly civil matters.
And from that explanation that you just made, is that one of
yes,
an example of breach of contract?
That's definitely a breach of contract. That is definitely a breach of contract.
And normally, what are the maximum or the minimum punishments that one can actually get for such crime?
Okay, for civil matters, it's not a crime. It is a civil wrong.
Okay.
Okay.
A civil wrong.
Yes, it's a civil wrong. So it's not a crime. A crime are only likened to criminal matters.
Okay.
Yes.
Okay.
Okay. So for an instance like that, like I have said, it is what you pray to the court for. The court is not Father Christmas that will come and surprise you with a gift.
Okay.
No.
You have to pray for something.
Yes, you have to pray. You have to ask the court for, but it has to be within the remit of your transaction with the defendant. Okay, so you cannot now come to the court and say, well, I contracted this man to do my suit. I paid him 500,000 leons, old note, for him to do my suit. Then when you come to the court to pray for the court to give you relief, you now say, well, because he did not do my suit, I want you to send him to jail, or I want him to give me 500 million leons. That is outrageous. The court will not consider that. And because of something like that, you will even jeopardize even your own action, because the court will now see you as a greedy person who wants to come and use the court as a conduit pipe for fraud, because you are now occasioning fraud.
Exactly.
Yes.
Exactly.
How can you give the man 500,000 leons to do your suit, and you now come to ask the court that the man returns to you 500 million leons?
So normally, how does the court settle such kind of matter?
It's what I have said. The court just have to give an order.
An order?
Yes.
An order that will suit...
Yeah, the court will give an order to the defendant, okay, that you have to pay Mr. XYZ the sum of 1 million leons.
Okay. Does that always come with an interest of what the person may have spent?
Yes, if you pray for an interest. I have told you that.
Okay, if also the plaintiff pray for that.
Yes, you have to pray for an interest also.
Okay.
And the interest falls under a particular statute which the law provides for. So you cannot just pray for any kind of interest. I want an interest of 50%. No. The court has its way of determining how it gives damages and relief to the plaintiff. But you have to pray for it. Because like I said, the court is not Father Christmas that's out of its own mind. It will now say, okay, you have to give this person X amount. So this is what actually happens with civil law. At the end of the day, the plaintiff is given relief. He is awarded damages, you know, and the likes. Whereas in criminal law, the punishment is such that once you are found, you have been convicted, once you are found guilty, the punishment is such that you'll be imprisoned, or you will be fined, or you will suffer both imprisonment and being fined. And there are instances where you'll be sentenced to death. Even though Sierra Leone has now expunged that particular penalty law in our laws, we are now speaking about the law generally. I know. We have other jurisdiction where, of course, the death penalty still subsists. And when you commit certain offense, you'll be sentenced to death. For instance, offenses like treason, you know, and aggravated murder. You definitely be sentenced to death in this other jurisdiction. And I was a proponent who says that we cannot, as a jurisdiction, totally expunge death penalty from our books.
Why?
Because you have to look at the circumstances of the case. Some acts of murder are so gruesome that the person deserves to die. The court should now sentence this particular individual to death because, first of all, the first element that you look at is malice aforethought when you are trying to establish the guilt of the person. So you now have a situation where, let's say, you have a serial killer in a particular community who has now killed over 15 people. His own job in life is to kill people secretly where the community does not know that he's the one that is doing it. You know, he keeps doing it over and over again, and he does it in such a violent manner. You know, dismembering even the body parts of the individual. Like, for instance, there was a case of a young man who came back from the United States, and he was living with his mother and his father. Something went wrong, and he killed both the mother and the father and dismembered their body. When I say this, he used a very sharp cutlass and chopped their body into different pieces and put them into an oak-foot drum. Yes. Sealed the drum and sold it as oak-foot.
Where did this happen?
In Sierra Leone. So can you make a case for an individual like that he should not suffer the pain of death?
No.
So in these instances, it is my argument.
No, I understand.
It is my argument that if you look at the circumstances of the case, certain individuals should suffer the pain of death. Once the court establishes that it amounts to manslaughter, the person did not actually have malice aforethought, or was under the influence of something, because we have a lot of defenses like self-defense, we have automatism. You know, for instance, now if I'm walking the street and someone attacks me with a machete, okay, he tries to chop off my arm or any part of my body. And in the process of protecting myself, I just hit him and he fell down and he died. I should be excused by the law. You understand? There are certain situations that an individual finds himself, for instance, automatism. He has a defect of the mind. He has a defect of the mind. He's someone who is sick. So in certain days, he does not even know what he's doing. You know, he's off his mind, and he mistakenly, okay, for instance, now we have people who sleepwalk. In that period while they sleepwalk, they are walking while they are asleep. He does not understand what he's doing. In that period, he mistakenly steps on someone and the person dies. The court cannot sentence him to death because of that, because he does not know what he's doing. But a man who has lived in a community and is killing people, is a serial killer, he's killed 15 to 20 people. And that is his job in life, to be killing people. How can you take someone like that and you say we cannot sentence you to death, we'll sentence you to life in prison?
No, well, if you look at the principles of the right to live, I think, and you just mentioned that people can be sleepwalking. You can do something to defend yourself. And if we still have the law that states kill for kill, so how do you see that? How do you see that? Even though it is your own argument, and at the same time you look at the circumstances that you just highlighted.
So this is the crux of my own argument. The court look at the circumstances of each case. In law, the most peculiar thing about the law is distinguishing the facts of each case. So every case that comes before the court should be distinguished on its own unique set of facts. Okay? It has to be distinguished on its own unique set of facts. You cannot say blanketly that we can expunge the law.
Okay, it is the fact that it was blanket.
Yes.
Okay.
So now anybody who kills anybody in any kind of gruesome way will be spared the pain of death. So, you know, you will say, I will kill you, and we have the phrase in our local balance, I will kill you, I will live for you. Yes. How do you take such a statement? Someone who has now have malice aforethought, he has prepared his mind that I'm going to kill this person, and I will now go to Paremba Road, and I'll go lay down for him.
I understand.
Yes, so you see.
If you're just joining us, the program you're watching is Legal Matters, coming to you on TDN Africa Media. With me in the studio, I have Mr. King, who is here today to teach us, because today we're learning here today, to teach us the difference between civil and a criminal law. We're going for a short break. We'll be back, and then we'll get into the matter. Back to the program Legal Matters, coming to you on TDN Africa Media. I am your host, Amadu Esba, and with me in the studio, I have Mr. King. We are looking at the differences between civil and criminal law using the LAJ judgment as a case study for criminal law. So now, Mr. King, we've said earlier we want to use the LAJ judgment as a case study, especially when it comes to criminal law. A lot of people describe the LAJ judgment to be an unfair judgment because for them, they do not see the crimes that they committed to be a criminal crime. How do you react to that?
Okay. This is public opinion again.
Yeah.
So most people cannot, who do not have understanding of the law, should have an opinion. Everybody is entitled to an opinion, but there is also the legal opinion. There is the position of the law,
yeah,
which people should understand. There are certain acts that individuals engage into, which has been put down into law as certain violations. Okay, it could be criminal or it could be civil. I think one of the offenses that LGA was charged for was robbery with violence.
Okay.
And robbery with violence is a criminal offense in this country. Robbery with violence is a criminal offense in Sierra Leone. You know, if we are looking at it in the context of the criminal law, I was in the court when the matter actually started at the preliminary investigation stage.
Okay.
Yes, the preliminary investigation stage is a stage where, you know, witnesses are called before the magistrate court and evidence is brought before the magistrate court to determine whether there is enough body of evidence against the accused person for the matter to be transferred to the High Court. It's called remitted, for the matter to be remitted to the High Court.
Okay.
Okay? So, in the wisdom of the magistrate, he determined that, as a matter of fact, the evidence before the court in the preliminary investigation is sufficient enough for the matter to be remitted to the High Court. Okay? So that in itself was a pointer to the fact that there was enough evidence before the court for the court to consider that the prosecution has a strong case.
Okay.
Okay, because even at the preliminary investigation stage, the defense team tried as best as possible to kill the matter there. But because the magistrate thought that he has seen enough evidence and he believes that this matter should go to full-blown trial, he remitted the matter to the High Court. Okay? So the matter went to the High Court. And of course, witnesses, these same witnesses who had come before the magistrate's court were recalled, plus some additional witnesses.
Okay.
Yes, plus some additional witnesses. I think most of the people who were present that day, they came before the court and they gave the witness statements as to what they saw, what the experience, what was done to them, and XYZ. It was only one person who was slated as a witness in that case who did not show up.
Okay.
Okay, but all the other people, they actually came and they gave their witness statements. And to cut the long story short, in the evidence that was brought before the court, the judge considers that it met the threshold of beyond reasonable doubt, and he asked for a plea in mitigation. And definitely, we also, where LEJ was given the opportunity to speak before the court, and he said he took responsibility for his actions, that as a matter of fact, he was misled by some bad friends, and he did not speak particularly to the offense, or he did not give a confession to the offense, but generally, he was remorseful.
Okay.
Yes, generally, he was remorseful, and he felt bad for himself that he has gotten himself into that kind of situation again, because it's not the first time. And having said all of that in court, and the judge saw the remorse, he was not given the maximum sentence for the counts. That, and of course, his representatives made a plea in mitigation in his stead, and all of that counted in his favor, and he was not given the maximum sentence. So he's not serving the full time. That's usually when they say the maximum sentence. For instance, for certain offenses, the maximum sentence is 15 years.
Yeah, I think the judge made mention of that.
Yes, for certain offenses, the maximum sentence is 15 years. But because you have a very strong plea in mitigation, you know, the judge will consider the unique circumstances, and he will now reduce the custodial sentence that he will give to you. So this is what in general happened in the LG case, despite the opinion of the public that it was not, it is a criminal offense. As a matter of fact, the counts charges that was brought against him before the court are all criminal offenses. And it is not for me to say that the prosecution did not prove their case or the defense disproved the case of the prosecution sufficiently. A determination of the matter has been reached already and has been found guilty. And we pray and wish him well. And that we also pray that it does not serve the full time, that by some miracle somewhere.
Yes, when you talk about some miracle somewhere, some people are saying if he's dissatisfied with the judgment, yeah, from the high courts, he can as well appeal. Is that possible?
Yes, of course. As long as it's a decision of a lower court, it's appealable.
Okay.
Yes, so his representatives can advise him whether they need to appeal the decision of the judge. But once you are appealing, you should know that an appeal is a risky thing to do. Because,
why?
Because once you fail in your appeal, then definitely your custodial sentence will increase.
That's the case?
Yes.
So before one push forward for an appeal, you have to be
absolutely certain that a new evidence has now come into your custody that you now want to present before the court, that as a matter of fact the court did not take into cognizance this particular piece of evidence before it came to that decision. If you can properly canvass the court and convince the justices of the appeal court, then they will look into your matter favorably. Okay, but if you now go only to waste the time of the court, then this is why the court will now consider adding to your custodial sentence.
Does he deserve a presidential pardon?
Well, it is not for me to say. A presidential pardon is a prerogative of the president. It is the unfettered discretion of the president, taking into cognizance certain elements. You know, we all know the society that we live in. Yeah, so that's why I say we pray for some miracle to happen for him to be, for him not to serve the full time. Okay,
now, before we're almost rounding up, you know, we normally don't put down the curtain if you do not give us a little bit of something about the law before we go. The last time you talked to Sierra Leonean about what the law is, why we need to respect the law, and today what would be your parting statement to Sierra Leoneans when it comes to civil and criminal law?
Okay, most people don't know that the law is for everyone. I think it is a public perception which is a misplaced one. Well, the people have a right to hold that opinion about how the law is practiced in this country, that the law is for the rich people and the connected people. But as a citizen of Sierra Leone, if you feel that your law or your right has been trampled upon, you should seek redress in a court of law instead of taking the law in your own hands. Because the law is for everyone. For every single transaction and engagement that we have on a daily basis, it is bound by laws. You know, people are contracted to do certain things, and they just take these things lightly. They don't know that they are under contract. And once they breach the contract, you say, hey, well, a settlement, we are going to settle it eventually. But if the other party understands that the law guides contracts also in the civil regime of the law, then it will now contract the services of a lawyer, and then litigation will be begun in his stead, and then we'll go into court, and his rights will be upheld. Okay, people need to understand that there is a law that will definitely cover for their rights as individuals and as citizens of the country, as even citizens of the world, because we have certain stateless persons who also have rights. And once you trample on those rights, this particular individual has a right to seek redress in the court of law. So do not leave your lives open and say, our society, if you don't have connection, you cannot. No. Sometimes try the law. Come to the law courts, institute actions against big corporations. Do not be afraid. You just might succeed and your case will go down as precedent, as people will use tomorrow to say, in the case of Mr. Ba versus TDN.
I'm not going with TDN to court anyways. Anyway, this is where we bring down the curtain for today's show. I have been your host, Amadu Esba. Don't forget, this program comes up every Tuesdays and Thursdays, 11:30 to 12:30 in the noon. So don't forget to be with us on Tuesday again. I've been your host, Amadu Esba, and my guests have been Mr. Emmanuel King, and I'll say bye-bye for today.